Good morning, Judge Spilg.
Morning, Chief Justice.
How are you this morning?
Yeah, I'm good, thanks.
Good, thank you.
Except this chair seems to be some problem with it.
You are not comfortable,
It's, it looks like it's about to.
and we have not started asking questions.
Absolutely, I might fall off it.
Do you wish something to be done for it to be changed, or will you manage?
Well, let's see how it goes. I just won't recline.
Oh, I don't want you to fall off while you are being questioned.
We'll try.
Yeah. Okay, all right. You have made yourself available for consideration for appointment as a judge of the Competition Appeal Court. Today is the second day of interviews that this commission is having this month. Yesterday we had a meeting as the commissioners, and we took a resolution adopting selection criteria for appointment for judges in various courts. And one of the commitments we have made is that while on the one hand we will be robust in conducting interviews with candidates where it's required to be robust, at the same time we will have due regard to a candidate's human dignity and respect. We'll show respect and courtesy. Nobody here wants to or aims to humiliate any candidate or treat any candidate unfairly. So we'll try and strike a balance between making sure that there is proper questioning, but there is respect and courtesy. You understand?
Thank you.
Okay. Now, there are two immediate issues that we'll need to talk about. Before we do that, I just want you to take you through your CV briefly. What are your academic qualifications?
BCom, LLB, HDIP Tax, HDIP Company Law, and then an Advanced Company Law.
Okay, you might wish to speak a little up.
Certainly.
Yeah, BA, LLB, you said.
No, BCom,
LLB. Yes.
And then HDIP Tax, HDIP Company Law, and then an Advanced Company Law when the new Company Law Act came in.
Yes.
And all it fits.
Yes. You practiced as an advocate before appointment as a judge, is that correct?
Yes, I was an attorney prior to that as well.
Yes. How many years were you an attorney?
Very briefly. I think it was about a year. I was articled for, so I did part-time law, so I was articled for 2
Yes.
years, I think, with the article period.
And as an advocate, you practiced for how long before your appointment as a judge?
Can't recall offhand. I think I came to the bar in 73 or 74, and until 2009.
Yes. You were appointed as a judge of the High Court in 2009, is that correct?
Correct.
Yes. So that would mean you have been a judge for about, 14 years?
Correct.
Yes. And do you do a lot of commercial matters as a judge of the High Court?
The moment, yes, I have.
Yes.
Sorry, if the answer is over the period, yes.
Yes. In your practice as an advocate, did you also do a lot of commercial matters?
Yes.
Any competition matters? I know at that time
No, I
there
sat
might
on
not
the-
have been a competition
My apologies.
appeal court and so on.
No, my experience then was with the Security Regulation Panel on Takeovers and Mergers.
Yes.
I'd served there, I think, since 2004, but I may be wrong
Yes.
with dates. But it was more the experience that I had as an as council, involved with the kind of issues where there would be overreaching or attempts in the telecommunication industry, the airline industry, medical, and I think I mentioned telecommunication, medical as well. Might be one or two other areas where I had quite intense commercial experience in the dynamics of these industries: airline, telecommunication, media, and medical, pharmaceutical in particular.
You have acted in the Competition Appeal Court. How long have you acted?
I was appointed 2 years ago. I've only had one matter, and it was recently where I sat with the Judge President, well, two Judge Presidents, Judge President Monaghan and Judge President Malambo.
Yes. So you have only sat in one matter.
Correct.
Did you write the judgment in that
No,
matter?
I'm not the scribe.
Sorry?
It's still being drafted, but I'm not the scribe.
Yes. So is the position that you have never had the opportunity of writing a judgment in the Competition Appeal Court?
Not in the Competition Appeal Court. I did write 2 judgments in the High Court which did involve aspects of the Competition Act.
But were those reviews, or otherwise how would a competition matter have come to the High Court?
It had to do with the jurisdictional element. The one had to do with the jurisdictional element. The other, and it was actually recorded, I think it's reported in the competition law cases. The citation is there, it's in my application. The other, so there was a jurisdictional aspect. The other, trying to recall, but it had to do with some competitive issue. But again, it might be tangential, but I identified it in my application.
So when you seek to be appointed as a judge of the Competition Appeal Court, bearing in mind that in an acting capacity you have sat only in one matter, what is the basis on which you say you have the requisite knowledge and experience required at the Competition Appeal Court level that you would say we should take into account in
Thank you.
in deciding whether you should be recommended?
Okay. The competition law is fundamentally about, I think, 3 things. The one is to encourage economic development, and here we have our transformative elements which are quite unique. And it includes obviously the SMEs, the encouraging of SMEs, their growth, and then historically disadvantaged persons entering, having shareholding in corporations. The one level, the other is so that's the economic growth level. Then there's the anti-competitive element, which is to protect consumers or advance the interests of consumers in what may be highly concentrated markets. And the final one is the constitutional imperative. Well, there may be a fourth, and that is the respect for international conventions. I've had experience in aspects of competition law by reference to the pharmaceutical industry in relation to TRIPS, the TRIPS flexibilities, the Doha Convention, which is in regard to intellectual property, particularly with reference to pharmaceuticals, and access to medicine. So I may not have sat in a court, a competition court, but I think the experience I've had commercially and in these fields, as well as having presented papers on access to medicine at on international platforms, I was invited. I didn't promote myself for it. I did courses, and pursuant to the courses I did, I was invited. So I think I can contribute. I think I can contribute through experience and the application of the principles of market forces, look through the prism of a constitution, and the advancement of our people.
You don't think that, seeing that you have only had the opportunity of sitting in one matter, you would need to sit in more matters before you have reached the stage where you can say you are ready to be appointed to the Competition Appeal Court?
I think I've set out my CV,
I'm sorry, please raise your
I believe
voice.
I've set out my CV, what I believe I'm capable of, my application in many fields of law where I might have dealt with it for the first time. But that call is yours. It's the JSC's call. But I've laid bare what I believe I'm capable of, my
Yes.
ability in analytical thinking, in concerns for ultimately the various imperatives of legislation, understanding of what they intend to achieve. And I've gone through courses. I believe that, but it's your call. It's the call of the JSC, not mine.
Well, as I think you are aware, there is a complaint that was lodged against you some time back, which seems to remain unresolved. The complaint that was lodged with the Judicial Conduct Committee. I think that seeing that the JCC is effectively a body, a committee under this commission, I think I must apologize to you on behalf of the commission that the complaint hasn't been dealt with for a long time. It would appear that a recommendation was made by the Judicial Conduct Committee for this body to consider deciding that a tribunal should be set up to look into that complaint. We don't have all the information about the complaint here, so from that point of view, it's difficult to ask a lot of questions on it. But we decided that we would give you the opportunity of an interview. I don't know whether you might be aware what the complaint was about.
So are you asking me now, or must I wait until you've completed what you want to ask me?
Yes, I'm just asking. I don't know if you are aware what the complaint was about that
No,
I'm
I'm
referring
not.
to.
In
You
fact-
are not.
Sorry, I didn't mean to interrupt.
Okay, all right.
So, sorry, Chief Justice, if I may.
Yeah, if there's something you want to
If
say.
I may, yes, I would like to.
Yes.
I've spent something like 2 years asking. I've applied previously for this position. I, in fact, had requested for some time to be considered for an acting appointment to the Competition Appeal Court. I do not know why I wasn't. I was given indirectly, and I'm quite happy to share that with one or two, whoever may be appointed. I think it's inappropriate to disclose what I was told when I asked, let me go back a bit. When I became a judge, I'd applied to become a judge. During that period of application, I was approached by Mervyn King. Mervyn King asked me whether I would consider doing competition law work. I indicated that I think it would be unfair to parties, since I was applying for a position on the bench, to in fact take on a matter. He didn't say what matters they might be, but he suggested that I do that work. Now, he had a man of great experience. He was a judge at the time. He headed the King Commission. I was a member of that King Commission. He headed the insider trading task group for that legislation. I was the originating co-author of that piece of legislation, which became known as the Insider Trading Act, and you'll find it's now in the Companies Act. Why I'm saying this is that others believed that I had that capability, even at the bar. When I came to the bench, I requested the then head of that court to be considered. I heard nothing until many years later, when I attended a conference and there was an indication that there was some training. So I said, well, may I be part of this training? It would have been about 6 years ago, 5-6 years ago. And that, can I please be considered? I was then given what I believe is, in confidence, a reason. I'm happy to share that, but I'm not happy to share it on a public platform. That's number one. Number two, in regard to this matter, I think it should be placed on record that I was approached just before my interview with a letter, being the letter of complaint. I made my position known that I had for 2 years, and it is in the documentation in my application, I think it's a period of 2 years, asked to be advised of what the complaint was. I think the emails that are in that application, my application, I'm sorry to be long about this, but you've asked me, and I'm answering as best as I can. There was no comeback. But literally 10 minutes before my interview, I'm shown a letter. I explained that if this is what that was about, I know nothing about it. I recall the name Cost Consult. I recall the name Hoskins or Haskins. I recall nothing else about the matter. The only thing I could do was to try and Google my name with Cost Consult before I came in, to see when it might have been heard, whatever, because I did not read that letter. I don't know what date it was. I think it was 2017. I may be wrong. But I am concerned that having tried for 2 years, sorry, I didn't mean to ignore anyone, tried for 2 years to establish this, and then asked 5 minutes, 10 minutes before I'm interviewed about it. I do not recall it at all.
Thank you, Judge Spilg.
But I would like to say something else with respect.
Yes.
And that is, this body, the judiciary, asked me to go to Botswana and give a 2-day lecture, thorough lecture, seminar, to judges of the Botswana court on the Bangalore principles on the ethics of the judiciary. I find it, well, I can't say, it's not for me to make the call, but it appears that my peers do respect me, do respect my integrity, do respect my work ethic. If something slipped through the cracks, they slipped through the cracks. Again, Chief Justice, I didn't look at the date when the complaint was made or what it was about. If I could be assisted as to the date and the year. But I imagine, I seem to recall, because my first reaction was, why am I asked to go and give lectures on ethics if that is something that's before to another, in another country, to their judiciary, their whole judiciary. So I'm afraid I have been long-winded about it, but it is concerning that 2 years I've spent trying to get to the bottom of it, and 5-10 minutes before I'm interviewed, I'm then asked, and I do not recall it.
No, thank you, Judge Spilg. So your request or suggestion is that in the light of all the circumstances, the Commission should not attach much weight to it.
Well,
Is that?
I can't speak for the
Oh, you
Commission.
can't say
The Commission must make its call.
Yes. Okay. No, that's all right. As I understand the position, at the moment you are 74 years old, is that correct?
Okay, now we're talking of my shelf life.
Sorry?
You're talking about my shelf life.
I'm sorry, I can't.
You're talking of my shelf life. My sell-by date.
But am I correct in terms of your age?
Sorry, I think I was trying to formulate an answer and wasn't. I am 74 years of age. I retire next year. My appointment letter came through on the 26th of August, 2009. I was acting from 1 June 2009. I have asked the OCJ to give me a precise date of when my retirement comes up. I have not been given that date yet, but it certainly would not be later than 1 June, if I understand the acting appointment correctly, that it would be taken into account. So, yes, 1 June 2024 will be when I retire. I have indicated, though, if I may anticipate what's coming, and I hope I don't do it inadvertently, is that I have, and I put this in the letter.
Let me rather put it to you.
Yes, sure, with pleasure. My apologies.
As you have indicated, you would be retiring at 75, which is next year, you say, not later than 1 June, I think you said.
Correct.
Yeah, because Section 3 of the Section 3.2 of the Judges' Remuneration and Conditions of Employment Act provides that permanent judges in the High Court and Supreme Court of Appeal retire at 70 if they have finished a certain number of years in service, and if they haven't finished that number of years, they can continue beyond 70, but nobody can continue beyond 75. Is that right?
There is an exception with respect, Chief Justice, and that exception is if you've got a part heard.
Please just speak up again.
There is an exception, Chief Justice, and that is if you're sitting with a part heard. And in my representations, I've indicated that I, in fact, do have a part heard. I've indicated its nature. I asked the parties, which is the two accused and the state, what their expected duration of the trial would be, anticipating this question. The accused say if they are not convicted, the trial hearing, the evidence, will take 3 years. And it was 3 years as from the last day of term in March this year. So that takes me to 2026. The state is of the view that it will take 2 years. If I do convict, then there'll be a matter of sentencing. If I don't convict, according to the accused, it'll be 3 years. I can't rush the matter because of already allegations on the record that their fair trial rights are affected because of the a number of things, the health of each accused. The one is what we call an awaiting trial prisoner, effectively detained. And he has been medically examined because I felt it was appropriate at that time, we're going back a year or two, to establish when he could sit. He claimed he could only sit 2 weeks in every 4 or something like that.
But let me interrupt you.
Sorry, bottom line,
I'm sorry.
My apologies,
Let
Chief
me
Justice.
interrupt you.
Yes.
It's not my understanding that there is such an exception in the Act. The position would be that if your date of retirement arrives and you have a parted, you would continue with the parted, but it doesn't mean that you would that your retirement would be postponed. That's my understanding. You would continue with your parted, but you get discharged at 75 because the only exception, as I understand, the Judges' Remuneration and Conditions of Employment Act. Actually, there is no exception under that act, as I understand it, for anybody to postpone their retirement beyond age 75. You can stay beyond 70 under certain circumstances, but not beyond 75. Is your understanding different?
It's not that perhaps I put it incorrectly as an exception. I'm obliged to complete this case, however long it takes, however old I might be.
Yes.
That case, sorry, my apologies. That case cannot run continuously because of the medical certificates, and I was long-winded, I apologize for that. Because of the medical certificates, at the moment, the best I can do is 3 weeks running, which is being objected to at the moment, 3 weeks running, 1 week minimum break. They contend 2, but I've directed that they go and have a reassessment. So basically during this period, I am a judge being obliged to complete, and I believe that that period where I am not sitting, because I can't sit, not that I don't want to, I can't sit, I can be of use. Insofar as we're talking of a year and a bit, when I got appointed, I was seconded, is the right word, to the Land Claims Court. I believe that within the year, I was able to produce a judgment which I believe has an impact on what was perceived to be limitations of land claims, the way they fill out their form of giving a generalized...
I'm sorry, Judge.
Sorry,
I'm sorry.
Then my apologies, I've misunderstood that. I believe I can make a contribution reasonably
Yes,
quickly.
but Judge Spilg, what does that have to do with the question whether, as a matter of law, a judge can continue as a judge and postpone his or her retirement beyond age 75? Because that's my question.
Sorry,
it's a question of law.
Okay, my apologies. All I can say is that I am obliged to be here as a judge until that case is over. However you wish to use me during that period is the prerogative. Whether I can remain as a judge and still perform a function as acting, I don't know. If it's not possible, it's not possible. But I'm not, again, I'd understood that I can make a contribution immediately.
Well, maybe you can make a contribution, Judge Spilg. I said to you, or you knew where I was going with the question about your age, and you wanted to tell me, you said there was an exception. Actually, I put the question to you that at 75 next year, you will be obliged to retire. And you then said there's an exception. And you said if you have a parted, as I understood you, And I said, that's not my understanding of the law. My understanding is you retire, but if you have a apartheid at the time you retire, you will then continue with the apartheid. That doesn't affect the position that you are retired.
Yeah.
And of course, a judge is a judge even after retirement. So you just continue to finish, but you finish that case only. You are not there to start new cases after you have retired. There is a provision where if you have not reached 75, the JP can call you back to assist for not longer than 3 months a year. But that, I think, won't apply to you because you will have reached 75. So the point is, do you dispute the proposition that in terms of the Act, you will be obliged to retire as a judge when you reach 75 next year in June?
My apologies, I used the word exception incorrectly. No, I don't dispute that. All I think I was looking at the practicalities of my being obliged to, not being obliged, remaining on and being of use. But I don't challenge anything that has been said. I use the word exception inadvisedly.
Yes. Now, if one accepts the position that in June next year, at the latest, as you put it, you have to retire, what public purpose would be served by this commission recommending that you be appointed to the Competition Appeal Court when you have just 1 year to go before you retire, in circumstances where, if necessary and if you want to contribute to that court, you can continue acting, they can let you continue acting, but what purpose would be served, public purpose would be served by us having you recommended for appointment?
There seem to be two issues then. One is the fairness of treatment, where I am now regarded as expendable. I can make myself useful for a short period. The other is that I think I can contribute because if I can, I will have time. Up to June. I've got practical skills. I've got practical knowledge, which I can share. Now, if it's perceived that, well, I must just remain acting, that's, again, the JSE's decision. I'm not here to defend a position. I'm here to hopefully make a contribution. And then the question is the fairness of my input. That's all. But that's, again, with respect, the call of the JSE as to how they perceive such contribution as I can make and whether it should justify in these circumstances. And I've laid bare that right from the inception when I became a judge, I had asked to be considered.
Is there a difference between the contribution you can make during the remaining year as an acting judge and the contribution you can make as a permanent judge? Is there a difference in that contribution?
Chief Justice, I made 2 points. The first point was the fairness. You make the call on the fairness. That's it.
Thank you.
But it's not me to make that call either.
Okay, I will allow the Judge President to put questions if he has questions for you. Judge President.
Thanks. Judge Spilg, I'm going to go into different topics then, really, to deal with issues of the...
Please bring your mic closer, JP.
I was saying to Judge Spilg, I will go on to these issues that have been covered with you. In relation to the competition issues themselves, I wanted to first deal with your comment in your motivation. It's on page 34 of that pack, if you've got it. And
sorry, page 34.
34 of the manuscript at the bottom of the page. You say
Yes.
in paragraph D that you have a concern that competition law at present does not adequately integrate constitutional requirements, and then you go on to your experience. I just wanted to deal with that
Yeah,
first
sure.
part of it as to what did you have in mind when you said that? In other words, is that a reflection on the statute or the way judges have interpreted the statute?
No, I think it's firstly the precursor to the amendments to the Act of the Competition Act is very Eurocentric. In fact, while during this case where gave me the opportunity to sit, their words, their phrases, they do not. They seem to color perception that there's something special outside ordinary fields of economics, commerce, and understanding of anti-competitive behavior that now gets classification. But let me return to the Eurocentric approach. So it starts off with a Eurocentric, particularly in relation to intellectual property. The amendments to the Act brought about a significant change, but it also has created tensions because it speaks at the same time of economic development and obviously the transformative measures which I referred to earlier. But by the same token, and refers to the Constitution. Now, if you take one example, access to health care. Now, if we look at the first decisions by this Court of Appeal, the Medicare case, there the Competition Appeal Court did not flesh out at that time, the Constitutional Court did, but the Competition Appeal Court didn't flesh out the impact that the access to medicine under the Constitution had on the way one looks at anti-competitive behavior. Sorry, this was a merger. Sorry, my apologies. It was a merger and acquisition, which is also part of the Competition Act and under the court's jurisdiction. So there's that element to it, but added to that is a further layer, which I seem to recall it's in the same provision, the early provision, which then speaks to, but respect international law. That international law then brings back certain of the call it laws that are developed within the World Trade Organization as opposed to the World Health Organization. The World Trade Organization devised TRIPS, and I can speak about that because that's intellectual property, and the intellectual property issues, certainly in regard to the pharmaceutical industry, do impact competition law. They obviously do. The Treat Action campaign was successful in the AIDS issue, HIV/AIDS issue, because it actually went to the Competition Court. To the Competition Tribunal. And it resulted in a finding by the tribunal, and then when it came to the compensation element, they backed off. The pharmaceutical companies backed off. So I don't think we should lose sight of there has to be respect for the international laws because they are there and they do impact on us and the perception of whether you're going to invest in a developing country, South Africa, as opposed to another developing country where your laws may be perceived not to be conducive. So there is a need, I believe, to harmonize these disparate threads, and value judgments are having to be made because the Act requires us to look at all aspects, and one of the aspects will be our international accords such as TRIPS and the extent to which we are balancing our internal aspirations with economic reality of how far do you go and where can you draw a balance. So I hope I've explained as best as I can where I see it. We've got, as far as I know, 2 cases now. The, my apologies, the Medicare, so that's now the Constitutional Court case, and then the e-media case, which has to do with abuse of dominance, which did apply the jurisdiction, the jurisprudence of constitutional input into the considerations of the court. That is where I come from. Thank you.
All right. So the examples you've given, I think the Medicare is the Mediclinic case, the Mediclinic merger by the Constitutional Court, and the Glaxo welcomed related to licensing of antiretrovirals, and those are both examples of where the competition law worked. I understood from this, it worked for the values that you've talked about, right to health, right to health care, that you saw a failing in other cases.
In earlier cases, I think bear in mind that the initial decision of the Competition Appeal Court in relation to the was it Mediclinic?
Mediclinic, yes.
Mediclinic did not take that into account, and I think the legislation with its amendments is strong and powerful. I don't believe I am saying that that the Act is inadequate. I believe that the Act is remarkably flexible. But we're going to have to apply the Act to exigencies as and when they arise. And there is overseas jurisprudence in countries that have written constitutions which still inhibit issues when it comes to an area I'm familiar with, which is access to medicine. So I wasn't being critical of a process. I think I was being more that I can make a contribution to it in light of these various threads that need to be taken into account and which would have to have regard, in my view, to the facts and what facts need to be fleshed out and their dynamics, how they impact.
How would you deal with the problem that some of the more conservative thinkers saying is that if you move away from the consumer welfare standard to some other standard, there is no limiting doctrine? In other words, everything would be found to be unlawful. How do you, as a judge, if you feel the way you do, deal with that criticism?
I would simply apply our law as it is with the overarching constitutional considerations which would temper inappropriate cases. So, sorry, going through my mind was something, it might come back to me, which would give an example of that, where the law is there, you're not, and again, I'm uncomfortable by pigeonholing things. We need to appreciate the consequence, and I think that's where I'm coming from. We need to appreciate the consequence of using these, what may at first sight be rather extensive and overly progressive, but law develops from a standpoint of taking what there is, not jumping, but through logical progression, applying and characterizing matters in an order where you can rationalize a a greater priority, or a priority. And so I don't see there needs to be a conflict. There needs to be a characterization and understanding of the dynamic, and then bringing across in a rational a way that can be, I don't like to use the word sold, but that's the word that comes to me, that can be rationalized legally and practically. So no, there's no jump to another dimension. There is, and if I think I did attach the presentation I made on artificial intelligence and law, and there I referred to a paradigm shift. It had nothing to do with some revolutionary node. It is take your dynamic, understand what you're dealing with, and bring to the fore your key principles. So, access to medicine. One looks at a question of, well, what trumps what? Can one rationally explain whether the constitutional value of right to life, where you have a pandemic, where you have epidemics, how is that supposed to be balanced against the right, the monopolistic right established by a patent? These are things we need to grapple with. The Eurocentric view was that, well, it doesn't, intellectual property is king. That has been ameliorated. So no, there is no jump. There is applying a set of norms, considering all of them, considering their effect, and then finding a way in which one balances in a rational way that can be brought across to others why this approach is rational, why it is not changing something overnight, but rather than taking a value that is more supreme than another value and putting that at the top of the hierarchy. I thank you for giving me that opportunity, because I think I've expressed myself better than I did earlier.
Thanks, JP. Thank you, Judge.
Thank you, Judge President. The Minister indicated he doesn't have any questions. Commissioner Malema.
No, thank you very much, CJ. I just want to make a follow-up on the questions the CJ asked. Maybe put differently. Judge, when are you retiring?
I'm told, I believe, 1 June, should be 1 June 2024. A year and a bit, that's all.
1 June 2024.
Correct.
Now, you saying you are told. I want you to tell me, because you should be knowing yourself, when are you retiring?
I asked, sorry, Commissioner Malema, I had asked about a month and a bit ago, what is my actual retirement date? I am waiting for a response. I have not received it. The calculation is that my appointment, my letter of appointment came through on 26 August 2009. I know this because it was 2 days before my birthday. That's not because I have a great recall. Just happened to be that. My acting appointment, I had acted from 1 June. And as I understood it, as long as you act continually until your appointment, that is taken as the period. So that's why I believe 1 June, but there may be considerations that may or may not advance it. But I believe 1 June is on paper the appropriate date. There were earlier acting stints. I don't know if they're taking into account. I'd understood it's your permanent, continual acting period. So that's why, my apologies. That's why I can't be definite. What I can definitely say is it is no later than 1 June 2024.
I know it's our responsibility to decide to to appoint you or not to appoint you. I mean, to recommend to the president to appoint you or not to appoint you. But do you think it's fair for this body to recommend to the president to appoint a person who's going to serve for less than a year in a court where we're actually struggling even to get people? If we appoint you and you go on retirement, it's almost going back to square one. So, in all fairness, and we are going, if we recommend you, we are going to recommend you now, it's April. We don't know when the president is going to appoint you. He takes his own time. He might appoint you in June, after June. He just appointed now the SABC board. It took forever for him to appoint that board. So it might take whatever period for him to appoint you. And that becomes less than a year into retirement. Really, do you think it is fair for not that you are appointing, but in helping this commission to come up with a good decision? Because after we take a decision of appointing, we'll get subjected to scrutiny. We get criticized, we get applauded and all of that. Do you think it's the right thing to do at this stage?
Fair enough. Thank you for the question. I see fairness slightly differently. If I was competing, there are 5 vacancies. If there were 5 candidates standing, I would not have applied, because I would have taken a position where somebody else could have gained that experience in long term. So I see fairness from that perspective. There are 2 candidates and there are 5 vacancies.
But what do you do to the fiscus? I mean, you are going to get some increase for a position that you almost served for less than a year.
Sorry.
And then you go for the rest of your life with that package. What do you say to the fiscus?
May I assist
Yes.
then? The starting point is that there is no extra remuneration. So if that was a perception by anyone who's not a judge, then if I could assist there, and I'm sure the judge presidents will confirm that, there is no extra remuneration. There is only extra work.
Okay.
Nothing more.
Now the last one, CJ, through your indulgence, the complaint, I know you don't know the merits of the complaint and all of that. And the same happens to all of us, that this complaint is here. We can't do anything about it. We can't say it is a strong case or serious allegations or anything of that sort. And I also don't know, because when they say there is a complaint, in the absence of anything before us, we then Google you, then there will be this tax issue, or maybe we don't know what the issue.
What issue? My apologies.
No, I'm saying I'm not saying there's an issue on you. I'm saying if I were to Google you, and then they say there is a tax issue about you, I didn't Google you, or there is sexual harassment against you, or there's GBV against you. I don't know what the complaint is, but the complaint is firmly there. It's there. It's undisputed. The JCC, they've received the complaint. And the problem is that on our side, the matter is not being resolved, right? And we also don't know what the issues. Will it be fair for us to appoint you without knowing even the merits of the complaint? Because it is undisputed that there is a complaint. It is undisputed. And only after we appoint you, the details, because remember, that's why we said this matter, if it can be resolved outside, let it be resolved, because we didn't want to raise this out of respect in the presence of the media. But once they hear now that there is a complaint against you, then they go and dig up on the complaint, and boom, here we have appointed a person who's accused of serious violations. Will it be fair for this body to appoint you with this complaint that it is before us? Or should we wait and say, let's have the matter resolved, and then we can look into your candidature, perhaps, if it's possible? Thanks, CJ.
Thank you. The OCJ had 2 years to find this. I wrote. It's there. It's on the application, and the correspondence is attached at the end. I glanced at it. The only complaint, sorry, I can't say only complaint. The complaint is regarding a delay in a judgment, delivering of a judgment. That's all. It's got nothing to do with my behavior. It's got nothing to do with anything else. So, I believe my record is good in delivering of judgments. Again, I'd like to know what year that was, but I don't think it's current. And I believe that the profession as a whole, through their input, considers me to be courteous, considers me to be hardworking, diligent, applying. So it appears to be a matter concerning a long outstanding judgment at that time. But again, perhaps the Chief Justice can assist us to the year when the complaint was lodged. But
Thank you, Judge.
Sorry, my apologies. I hope I've answered.
Thank you, Guy. Thank you.
Thank you, Commissioner Malema. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge.
Good afternoon.
The comments by BLA, the issue of late delivery of judgments, and they've also noted the criticism from SCA on the matter of the City of Joburg Metropolitan, and the court noted interference and intervention in the matter, and the inappropriate conduct. Probably to invite your comment to deal with
Yes.
this part of criticism.
Yes. So what I did was I prepared a response which I believe the commissioners have. One in response to everyone other than the BLA, because the BLA appeared to invite a detailed response effectively dealing with allegations made, whereas the others, Nadal would be an example, asked, well, how do I juxtapose, how do I put in context the findings of the Constitutional Court and the SCA with regard to my refusal to recuse myself in a matter, and it was appealed, my refusal to recuse myself in a matter that is ongoing 4.5 years, and it is covered there, but if I may, what I have attempted to set out on reflection, that case started, and I'd forgotten about this, that case started when I was still an acting judge. I'm talking of the Ngobeni matter, because that's the one that's come up. That was, I think it started in early August of 2009. It proceeded until September, late September 2009. My appointment came on, as I said, the 26th of August. So I carried a lot of my profession with me. I carried, I believe, an aggressive, a litigating lawyer, because that's what I was. I also gave opinions, but I was a litigating lawyer. And I think that came through. But I also would like to think that in my explanation, I have addressed that I was searching for truth. It was a very difficult case, and that's why I've put in the short and the longer, the appendix contains a very, what hopefully is a detailed response. I start off by saying that if I found in favor of the plaintiff then, and the police were justified in shooting, I would have done an injustice. And I pointed out that I had, shortly before the case started, made a finding as to how police do react and how they're compelled to react in situations where, on what the police's version was in the civil case, that I understood that I've got to, I cannot do something that would undermine what I had said earlier about their responsibilities and how they can enforce it. But I also said that if I found in favor of the police, but that person that my finding was incorrect, I would again do an injustice. I then identified my approach to how I would weigh the evidence. And the reason I had to do that, and I started realizing the motivation. The person who shot an Inspector Ledwaba was dead. The original investigating officer was dead. How does one assess where, at the end of the day, it's an assault? It has an element of an assault on an individual. I had to disabuse my mind, obviously. He ended up being paralyzed from one of the shots. So I'm either going to make a finding in favor of somebody who pointed a gun at a policeman, or I was going to make a finding against the police when they were negligent in taking his firearm, which he said was cocked, and inadvertently pulling the trigger. I explained that I was uncomfortable in using an onus, because an onus in a case like that, where the consequences are so grave, both sides, a policeman who was justified in shooting or a person who should not have been shot. He was doing nothing, and that the scene was swept, basically. So what I did was I explained right in the beginning of my judgment the factors that I was going to take into account. I was going to look at the forensics. I was going to look at the evidence overall, and I was also going to look at what the procedure police, the standard procedures that would be applied if there were two people at a scene, which is what the police's version was, as opposed to one person being the plaintiff only. I did as thorough a job as I could, but my search was for truth. What I realized on reading the SCA's judgment was that abrasiveness that I came with as a counsel, and again, I only appreciated it when looking at it again, that it's a different outlook between that and the responsibility of a judge and the perceptions that are created by either an abrasiveness. And what I'd like you to draw from this is where I am now. And what I've tried to indicate is that insofar as there was a complaint about the way I conducted the inspection, I've explained that. I explained why I could not visualize the scene from the photographs. It became difficult. And when that becomes difficult for a presiding officer, I believe he has a duty to go and resolve that in his mind by going to the scene. An elaborate scene was created for me. We were just going to look at the scene so I get a picture. And I'd actually asked counsel for the defense, have you seen the scene? The answer was no. So it was in a way not the blind leading the blind, but an uninformed. I was going to receive an uninformed argument, and I was uninformed. I was having difficulty visualizing. But when we got to the scene, what then emerged was, so basically, it is the city of Johannesburg, but it was, but their rights have been subrogated by either insurance or reinsurance company. So basically, the claims manager or whoever was the representative had then created a scene. And the vehicle in which the plaintiff was also brought on the scene. So they wanted to take measurements, they wanted to do things. I explained to them that to do all this is going to be incredibly difficult. Does anyone have a camera? Let's take photographs and let's see. There were photographs by the police had taken on the night. So there were those. They said no one had a camera. I enjoyed street photography, so I always had a camera in my car. So I said, here, I've got a camera. Take photographs, take what you want. No one offered. So I said, well, then I'm happy to take the photographs. Tell me what you want me to look at. I will take them. If there's something that I find that I think may be relevant, may be of relevance, I will tell you and can be taken. What the parties did then was to have detailed measurements. They prepared the detailed measurements. They described the measurements that were taken, and those photographs all became part of the record. So I was of the view, wrongly, that it was unnecessary for me to provide a minute. It was wrong because Mr. McKesson, sorry, the owner of the vehicle that was brought, it turned out that vehicle, in fact, was the very vehicle that was driven by the plaintiff on that night, and it still had holes in it. He then wanted to explain the holes, or he was asked, but there was both the exterior door and then there was the inner panel. And instead of noting or asking him to say nothing, because I think that it was quite fluid. I was being shown measurements and things were happening.
I'm sorry, I'm interrupting you, Judge Spilg. Can I appeal to you to try your best to give concise answers?
With pleasure. But I am basically being asked about something that I've actually responded to in that note. So I'll be short then. My answers and my rationale are in the appendix. Insofar as where I am now, insofar as the inspection is concerned, I've given a judgment on inspections in land claims matters. I believe it is a thorough roadmap, so I believe I've gained from that. Insofar as the question of my temperament, my running a court, whether I'm descending into the arena, that matter before the Constitutional Court and the SCA, the recusal applications, the Porritt matter. There were, and it's written in my note, 1,800 or more pages of founding papers where effectively 4 years of that case was put through a microscope, and they challenged everything I did. The basis, saying I was descending into the arena using Ngobeni, I refused to recuse myself. And and then it was taken to the SCA. The SCA upheld my decision. They then asked for reconsideration by the SCA. It refused. It then went to the Constitutional Court, which refused, and then again a reconsideration was sought. So I believe I've been taken through how I conduct myself. And I believe that the considerations of the balance of the legal fraternity as to my temperament and my conduct, how I run a court, does reflect that I am not that person, that abrasive person that came in and threw my toys out the cot.
Thanks. My last one. So that when doing deliberations, I don't become unfair to you, as you won't be part of it. CJ asked a question that what will be the difference acting now till your retirement and being appointed permanent?
I've-
And I want to confirm what was your actual response to that question.
Fairness. Fairness. A person who, right from the beginning, had been identified while at the bar as having the capability of being in that court, not being given that opportunity right through my career. And eventually, through Judge Victor, 2 years ago, I think, when she was acting, and then Judge Valley when he was acting, there were no cases that came through for me at that time. So I've been waiting and I've been sitting and I've been waiting. It's your call. I'm not going to go with that further. It's a matter of fairness, as you perceive that fairness, as to whether there should be some form of recognition to being in that court or whether it's going to be an acting. I'm not making that call.
Thanks. Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Baloyi? Sorry? Follow up? Okay. Commissioner Malema?
Thank you. No, let me understand this. That you have been identified from the bar and then this has not been happening and all of that, then you say fairness. Do you think you are entitled to this
No.
position?
No.
Because
No,
that
it's-
explanation comes across as saying, I'm entitled to this
No.
position.
Not at all. It's
Yeah.
something for you to consider. I'm just raising it. I'm not saying one way or the other.
Okay,
Thank you.
thank you.
Thank you. Another follow-up? Okay.
It's a quick one, CJ. Have you applied for this position before?
Yes,
Which year was it?
I think 2 years ago.
The same position of this?
I believe so,
applied for?
yes.
Okay, I missed that point. Thanks.
Thank you. Thank you. Commissioner Baloyi first.
Thank you, CJ. Good afternoon, Judge.
Yeah, afternoon.
Yes, Judge, my concern is about your availability.
I'm sorry to interrupt you, Commissioner. I just want to say, with regard to the date of your retirement, Judge Spilg, the Secretariat has informed me that they have contacted a senior person who deals with the discharge of judges and benefits, and it's somebody that I know has been dealing with these
good.
things for a long time, yeah. And she says that your date of retirement is 22 March next year.
That's good.
Okay, all right.
that's
I'm
nice
sorry
to
I
know.
interrupted you.
Well, then, thank you then. Then it's even shorter.
Yes,
It's March.
thank you. Judge Spilk, I started to say my concern is about your availability. You, in this current matter that you are doing, you say that it's set down to sit 3 weeks of every 4 weeks. Now, that's what you say in writing, and I think when you were speaking there, you might have said 2 out of 4, but whichever it is, it seems like you're therefore not available to, in fact, discharge duties if you were to be appointed to the CAC, because on that formulation, you left only with 1 week in a month. And I don't see, and if you care to comment, I don't see how that works out to avail you to sit in the CAC if you were to be appointed. Do you have any? Do you want to comment? on
Yes,
that?
certainly. There are 2 comments. The first is that is my optimal, is 3 weeks out of every 4. They contend that they can't. They raise their need to prepare. Again, each time they do it, I've got to consider their fair trial right. I've got to weigh the amount. We're talking of hundreds of thousands of documents, by the way. So far, I don't know how many tens of thousands have been, but Mr. Porritt is in prison. He claims that he doesn't have adequate access to all the documents, etc., etc., etc. So every now and then, I've got to give more time, but it's got to be motivated. That's why I'm not prepared to say anything under that period. That's the first thing. The second thing is that the Competition Appeal Court sits, I think, 1 week at the end of every term, or is now trying to be more accommodating as to when, but effectively a 2 week, I think a 2 week, 1 week for preparation and 1 week for the hearing. And it appears to be, but then I'm subject to correction. I don't know, but I'm sure the JP will enlighten everyone during your caucus that it's unlikely to be more than 2 weeks in every term. That needs to be set aside. So it would appear not to be a problem.
Can I just put it this way? If we work off how you formulated it, you've worked on the basis that it will be 3 weeks of every 4 weeks. And you must have thought about it, reflected on it, and decided that's how it's likely to run. And
No, I didn't say.
I
My
accept
apologies.
that. May I just finish, please?
Yes, you may. My apologies.
I accept that you say that the parties think differently, but on your planning, you work on the basis, and let's assume that is so. That's how it plays out. That, as a matter of fact, you sit every 3 weeks of 4, right, and include preparation in there. Can we at least accept that that leaves you potentially with just a week to be available for the CAC work? You've now said there will be a week for preparation. Then you don't have that time for preparation. So we're likely to run into the trouble that because your trial must take precedence, I would assume.
Yes.
We are likely to run into the trouble that you get appointed, and yet through no fault of your own, you're not available on this formulation.
A term is three months. The
Sorry.
term with respect is 3 months.
Yes, how does that help?
Well,
I'm not sure. How does it answer what I'm asking you?
Because we work around that period. We can work around that period. So last week of term, the last week of term would be available. Week before that would be available. And the reality, because I've been conservative, the reality is that there are applications and there are requests to have longer time to prepare between the periods. And the difficulty I have as the presiding judge is the concern about a fair trial right. So when Mr. Porritt says, I have got hundreds of documents to go through, I don't have them with me, or I need to consult, there's a limitation to how he can consult, or he claims there is. So effectively, that is very conservative. Historically,
Yes.
it is not so.
Okay. Thank you. Thank you, Judge. Thank you, CJ.
Thank you. Before I go to the minister, I just want to say we are not doing very well in terms of time, commissioners. Obviously, if there are strong issues that you feel haven't been covered, that you think are important to be covered, by all means, I'll let you ask questions. But I'm just asking everybody to reflect and see whether whatever they may have wanted to ask, whether it's really important given the time constraints. Minister? Oh, okay, all right. Commissioner Maru. Okay, please. Marum Wahai.
Marumo Ahai.
Yes, thank you. Commissioner Malema has helped me, so I think I'm improving.
It's sad because even his name is always butchered, you know.
I'm sorry.
But I'm indebted.
I'm sorry.
A good afternoon, Judge.
Afternoon.
When you started, I got the impression that even though you don't have much experience in competition law issues, there is an issue that you seemed to be more interested in, which is mergers and acquisition. You kept on referring to that. And when I looked through your work, I could not find a judgment that I could actually talk to you about.
that you have, and of course, I understand the limitations and your experiences in terms of not having those kind of competition law judgments, and I take that. But I'm curious, when a judge is appointed to that court, which I consider very important, and it seems like I get a sense from judges of the High Court that this is just another court where we can come with our experience and be able to perform our functions. And that might be true to some extent. But I just want to test your engagement or your thinking around competition law issues generally, and specifically to those that I'm going to pose to you. And I think that is important because I need to have some sense of comfort that as a judge, you have thought through about competition issues, both on the law and the economic side of things. I want to ask you, in relation to mergers and acquisition, obviously Section 12 and Section 12A of the Competition Act deals with mergers. The other one defines what a merger is. The other one deals with the requirements and all those kind of things. The question that I'm not sure if you have thought about this, but I would really like to hear your views on it. What role does public interest play in mergers generally? And how should South Africa approach the issue of mergers, which on the one hand, they seem to be promoting employment and they will lead to job opportunities. But on the other hand, they seem to be restricting new entrants into the market. How should we deal with that, and how should we balance that? It's just something that has always been on my mind. I just want to hear your views on that.
Sure. But I need to take, if I may, there are three assumptions made. The first is that I'm focusing on merger. No, I see it holistically. So competition law is competition law, warts and all. So it's not, I wasn't trying to.
So sorry, Judge, I was asking just to be fair to you, to ask you something that you have exposed
No,
to.
I'm more
and
than
I was
happy
just
to.
asking in relation to what you said. I was not making an assumption that you are.
Obvious. Sorry, I misunderstood then. Insofar as merger and acquisitions, my experience was at the Security Regulation Panel, where I was a panelist, I think the appeal panel, for 3 or 4 years, 2004 to 5 years. So again, it's I think it's Section 12A is mergers. So 12, I think I'm right. But what it requires is to take into account those earlier values that are set out right in the beginning, the purpose of the Act. So yes, it is a difficult issue. And again, I think what one has to do is understand the factual matrix, the facts, sorry. Understand the facts. Understand the dynamics of A, where we are now, and B, where it's likely to take us, because that's what mergers and acquisitions is about, and the concern about the monopolistic or cartel environment it might create, and all the other problems it might create. So there is a balancing. I think unless we have a specific case before us where that is weighed and said, well, what impact will it have now? Does it have an immediate impact? But then again, does it have an impact in the future? And then we've also got to have regard not only to its dynamic in A, with regard to employment opportunities, B, the concern about concentration, C, the uncompetitiveness it may result in, and D, if I haven't mentioned it already, the impact on the consumer and the long-term effect that all these may have on each of those variables. So I can't give you and say this is at the focus. These are the tools that we have. these are the things we should be concerned about, and not just now, but what is going to happen, and that's the real problem, I think, and the quandary, is do we see it as immediate short-term? Do we see it longer-term, a 5-year? Or should we be looking at these issues and not speculating, but informed decisions based on the expert evidence presented as to where will it really take us to? And is it beneficial overall, if not a weighing of those? But I can't take it more than that in this forum.
No, it's fine. I'll leave it at that. I'm going to ask you another question, content-based, because I want to satisfy myself that the person who's going to sit in that court really does understand the issues that generally arise. What is your view on the dichotomy between horizontal and vertical restraints? And in particular, what should be the South Africa's approach in relation to rule of reason and per se restrictions, per se rule?
Sorry, rule of reason and the per se?
The per se rule.
Again, I think you can accept that I am not steeped in the subject.
It's fine.
But I think you can accept that these are terms that are used to describe a situation and a possible outcome or a deeming situation. But at the end of the day, there are countervailing, as you've just pointed out. You even have the situation of vertical affecting horizontal, horizontal affecting vertical. So even if we stayed just within a paradigm, we may not be able to stay within one paradigm either. But if we are looking at vertical and we're looking at horizontal, there are a lot of impacts. And to then try and classify, and that is my concern about the way it's been approached. One's got to open up and not compartmentalize, because there are nuances. And when you hear, and when I heard argument, what is coming through is sometimes you're trying to fit a round peg into a square hole, because that is the norm, that is the perceived norm internationally. And again, I'm not knocking it. They come with a vast experience, and they've been able to hone in on a phrase that explains something much bigger.
I think it's more complicated than that, but thank you very much.
Yes, but also thank you, Professor Maruma Achai, because I want to follow up just on one small issue. It's not...
Commissioner Ngwetobe, please follow up.
Yes,
that's the last person I have on my list.
Yes.
Yeah, thank you.
I was trying to restrain myself.
Oh.
but Judge Spilg, if I could just, in relation to the 2 points that were raised with you, the per se rule and the rule of reason, maybe to simplify it, what is the difference between Section 41A and Section 41B of the Act?
You're asking me, basically, I think if I'm correct, 41A deems certain things, 41A is about a prohibited practices, so Section 4 is dealing with prohibited practices.
Well, both of them deal with prohibited practices. But
yes.
What's the difference?
Well, sorry. Now you've got your horizontal and your vertical. Now, I can't recall offhand if 4.1 and 4.2 are the separators between horizontal and vertical. If not, then horizontal has a general consideration, and then you've got your specifics. That's my recollection, but all I need to do is Google the Act, call it up, and I can tell you straight away, because it's that simple.
Thank you, Chief Justice.
Thank you. Commissioner Pillay, you are the last one.
Thank you, Chief Justice. Good afternoon, Judge
Afternoon.
Spilg. Mine is only to deal with the 2 objections that have been raised against your application, Judge Spilg. And in relation to both of them, you were given notice of the objections and you've responded comprehensively in writing.
Yeah.
I just want to summarize your responses so that we have it on record. In relation to the objection by Makgakgola attorneys, the essence of the objection was that they appeared in a matter, that represented litigants in a matter before you, that they didn't get a court order from you which to enable them to tax costs. And I think your response was that you handed down an order as you should have, but that the responsibility to get the actual physical copy of the court order, that's left to the attorneys to sort out, and it's not something that falls within your purview. Am I correct? That's your response?
Correct. That they need to go to my registrar or registrar, get the file, and as I showed on that screenshot, has got that order that was given, and it was merely a matter of the attorney, if they were in court as they claim to have been, to have taken that file to the typist and had the order made.
Thank you. The second objection is the one from Koikanyang Incorporated, and it relates to the Grace Childcare matter. The essence of the objection is that there was an urgent application before you, that the matter was argued in August 2023, and as at August 2020, and as at March 2023, the judgment in that matter was still outstanding. Now, your response, I think, as I understand your response, is that there was an inspection in loco and you don't give the exact date of the inspection, but you traveled out to the site?
No, I didn't. I directed that the parties go out.
Right,
I
so
was not involved in that.
You weren't there at the time?
No, I told them that the simplest way of resolving it was if there were, remember we're talking of what is removal of people from a stand of land. They said that they were there. The city had claimed that they were only demolishing or removing those who did not have structures. There were photographs. It was a simple matter. Instead of all the fancy arguments that I was being presented, it's an urgent court and it was a busy role. They go out, they look for themselves, they report back, because what you see can't be hidden. It's a simple matter.
May I just ask, did the court reconvene after the inspection?
Yes, I was told that they had identified which and who was and was not there.
The question is, did the court reconvene?
Yes, we did.
Yeah, that's the answer.
And the matter was argued and it was left at that stage?
No,
no judgment has been handed down?
No, what happened was I was told, I can't recall when argument, I think argument may have preceded. They then were told to go out. There may have been further argument, but what did happen was that the city said that they accepted that those who were there or had been there should not have been removed. And that was it. So the urgency was now dissipated. The question, and it basically had been resolved by the parties. When I was eventually told, because I had a lot of stories before then, but what I eventually was told during the course of whether it was argument or discussion or an understanding of what that inspection had revealed, that I was satisfied that the city and the party had understood in clear terms who could remain, who had the structures and who didn't. My recollection is that names of the individuals, because there was a group of applicants, not just one, were identified and was accepted. And if I could just add to that, is that I've referred to the fact that nobody after that, neither for the applicant nor the respondent, asked me for a judgment or decision or ruling. So I had accepted that they had sorted it out.
Thank you, Chief Justice.
Thank you. May I just follow up?
Yes, sure.
Was this an urgent application?
Yes.
It had come before you in August of 2020?
2020, I think.
2020.
It was during COVID.
Yes, during COVID.
Yeah.
And are you saying that as we speak now, it is true that no order was made and no judgment was made? There may be an explanation, but I just want you to confirm.
Yes, correct, because there was no need. And nor had anyone asked for it afterwards.
Was there a settlement agreement between the parties?
No, there was no settlement. They'd sorted themselves out, it seemed.
Outside of court, or did they sort it out outside of court?
They told me, the city said that that they accepted that those who were entitled to have been there and who could show that they were there at the inspection, they were entitled to be there. That was it. And the applicants accepted that. I think there were 1 or 2 people, or maybe 3 or 4, who could not show that there'd been any demolition, and that was all accepted. So that was the end of the matter. I moved on to my next matter.
But that's strange for me, Judge Spilg, you know. As far as I know, a matter comes to an end, a matter in court comes to an end because there is an order of court or a settlement agreement. I don't know of any other way, because of course, if one party withdraws the matter, that's another way. But based on what you are telling us, there's no settlement agreement, there's no order of court, there was no withdrawal.
Yeah, correct. And that, in fact, has happened recently, where in the land claims.
Yeah, please don't tell me about the other one.
No, I need to, with respect.
No. This is a matter which comes before you. It's an urgent application.
Yes.
Parties go out to have a look. Was it not your responsibility to ensure that there is a formal ending of the matter one way or another? Either the applicant withdraws the application if they have reached an agreement, or the parties conclude a settlement agreement, or you issue an order one way or another, rather than have it just pending.
With respect to what I was being told is that there's nothing pending. They've sorted it out. And it has happened, and I need to explain this because the perception is that there is no alternative. In the land claims, I'm told it's settled. I have now insisted, not insisted, I said, could I please have an order so that we can close the file properly? But it does happen.
But in the absence of a settlement agreement or a withdrawal or an order, what is the status of that file? If the head of court wants to deal with it, to say, is this matter finalized or is it still pending? Must a date be arranged? What does it do with it? What is the status of that file?
I would explain if there was a problem. But as I say, nobody asked me after that, and nor does that complaint say that anyone had asked me to provide reasons or an order. So they sorted it out. And I believe that is the end. That is the answer that I give, is that everyone had accepted that they had sorted it out amongst themselves. That was it.
Well, I'll let Commissioner Place
Sure.
put one question.
Sorry,
but I wanted to say to you, I think it's the responsibility of a judge who has been seized with a matter to make sure that there is clarity about the status of the matter going forward.
Thank you. Thank you,
Judge Spilg,
Chief
just
Justice.
Yes, Commissioner, please.
Thank you, Chief Justice. I'm sorry about this. I just want to put on record what the complaint is, in fairness to the complainant. The complainant says that the matter was heard in July 2020. It was postponed to August 2020 for an inspection in loco to be conducted. And then he says the matter was argued on about August 2020, which is consistent with what you've said today. It reconvened after the inspection in loco. And it says here that Judge Spilg reserved judgment on that day. That's what the complainant says.
Okay.
So in other words, the complainant is saying
Fair
something
enough.
different.
Yeah.
He says the matter was argued before you. They have been waiting for a judgment. There has been no judgment. That's different from what you are telling us.
No, well, it's a matter of recollection. I actually I asked my registrar when the matter came through if she could give me the file and could she give me any record. They can't find the file, and insofar as the record is concerned, there was only the one recording that was available, and as I indicated, the technician couldn't, or apparently it needs a technician who may or may not be able to get the second recording. My recollection, and it's my recollection going back 3 years, is that yes, there was argument. I can't recall when, but obviously I accept that it was after the inspection. But the argument would have gone on the basis, what are you guys fighting for? Have you not identified who is, who isn't? And they would have said yes. And that was it. as far as I can recall.
Okay,
CJ, just.
I think I would prefer to leave it to the JP of your court. He might wish to follow it up in court. I'm not sure. Okay, Justice Spitz.
Thank you, Chief Justice. Good afternoon, Judge Spilg.
Afternoon.
You have already accepted that the matter was argued before you,
Yes.
and surely your bench book should tell you how the matter was ultimately disposed of.
Yes.
Because we have a complaint here where the parties tell us, we argued the matter, the judge reserved, we went away, it's 2023, we're still waiting.
Yes.
And
my understanding was that they had resolved it, that they amongst themselves, when I had indicated, well, what are we really fighting about? Is there not the simple thing?
but
Sorry, my apologies.
but they didn't come both to you, did they, to say we have resolved the matter? You might have been told by
correct.
whatever source.
No, they didn't. In court, they were, it was apparent that they had identified who is and who wasn't, and that was fine.
Yes, but what I'm putting to you is, can we accept that after they'd gone on your suggestion to do the inspection, they never came both parties to you and said, we have resolved the matter? You heard through some source that they'd resolved
Correct.
it. But that's not acceptable.
Okay.
You can't have parties before you who have a dispute, and they bring the dispute as an urgent dispute. You're supposed to resolve it. You hear argument, they go away, and you hear from somebody that the matter was resolved, and as a judge who was dealing with the matter, you never do anything to get the parties back to confirm to you that the matter was resolved. You
Fair-
accept that?
Yes, I do, but nobody came back to me and said, where's a judgment or anything of the nature. So I think my assumption at the time was a fair assumption that if I'm wrong, well, I'm wrong, but nobody until this complaint has ever asked me where's the judgment or anything like that, neither party. So my assumption was that it had been sorted out.
Okay, you can see I've been battling to try and finalize, but Commissioner Malema
sure.
and the Prof.
Judge, which procedure is that one that after arguments and everything else, instead of issuing for judgment, someone must come and tell you to issue a judgment? Which procedure are you referring to?
No, I'm not referring to any procedure, but if a party or something slips by, then you will get some notification saying, we're waiting a judgment, nothing has happened. You said you were reserving, we haven't heard it. Nothing like that happened.
No. You owe us justice. We came before you, we argued, and you know it's the practice of the practitioners respecting judges. You can't be saying to the judge, when are you delivering? Because there's no such a procedure anyway. You can't refer me to any procedure. In the absence of that, are you saying for as long as there's no one who says where's the judgment, you will never issue a judgment?
No, that's not what I'm saying. What I'm saying is that I understood that through when the argument proceeded, because clearly there was argument after the inspection, I identified what was really there. What was at stake, and what was at stake had been resolved. Because through argument, it was accepted that these people were in fact there, this group, and another group, I can't remember, 3 or 4, were not there. That was it.
And you hear from someone that we're not even told about, that the matter has been resolved, meaning that you heard it from a gossip.
No,
Because the only procedural
My
way,
apologies.
if it's not gossip, even if it's written in the papers, you can't even cite that as a judge. Whereas an unidentifiable body, The only procedure is that they must come before you and say we have resolved the matter. They've never come before you, and in the absence of them coming before you, what do you do as a judge? Because there are a lot of young practitioners who are listening here. They are learning through this process. If the parties before you don't come to you to say we have resolved the matter, what do you do as a judge? Do you go and hear things through a grapevine? Do you go and read about them in the papers? What do you do for as long as the two because you are a court as you sit there. As long as the court has not been told by the parties interested that they've not resolved the matter, what is the procedure?
That is why I was hoping to get that recording, because it was in that
Judge
process
Spilg,
the various
Judge Spilg,
council.
I'm going to interrupt you, I'm sorry. The question is simple. What do you do in this situation? What procedure do you follow? The answer should be, this is the procedure. If you know it, if you don't know it, I don't know what procedure is applicable.
No, thank you. But it was prefaced on the basis that it's gossip. It wasn't gossip. It was the parties themselves during that hearing.
No, but Commissioner Malema is talking about after the inspection. He says they didn't come back to you, both parties, to say we have resolved the matter. And he's asking, where that has not happened, what procedure do you follow as a judge?
But before he answered, Chief Justice, you said to him, you heard from someone.
Yes.
And he confirmed that he heard from someone.
Yes.
So he can't now say he heard from the parties. He said he heard from someone, and then that the parties have resolved the matter. I'm saying, you cannot hear from someone or the paper other than the parties which appeared before you. In a situation where the two parties never said to you in court that we have resolved this matter, even if you hear it outside, as long as these two have not come before you, what is the way forward?
Okay. All right. The facts of this was that there was an inspection. I wasn't sure when we started this discussion whether the argument was before and after the inspection or just before the inspection. The Commissioner pointed out that the complaint indicated that there was argument afterwards, so I accepted that. So trying to recall what happened. They have their inspection, they come back. One of the council adopts a high-handed attitude effectively regarding, yes, but we've always had this position. I then flesh it out between them, and the outcome is there's an acceptance that those identified at that inspection who had a structure there could not have been demolished, because the city's case was that they never demolished any structure that was there. The outcome of the inspection showed that there had been a demolition. Those people, the occupants, had been then identified. There were others, 3 or 4, where weren't. During that argument, it was accepted that those, because that was the city's case. If you had a structure, we couldn't have demolished it. We couldn't. And it's clear because that's the law. So it was from the parties themselves during the argument where that arose. So it is hearing when that argument took place, because I believe there was argument before and after having been told what that complaint is. It wasn't just before. There was a sequence of argument, yes.
But Judge Spilg, if you now say that this is what was said during the argument that took place after the inspection, that there was an acceptance by one of the sides of certain proposition, if they didn't tell you at that hearing that the matter was resolved, on what basis did you not give an order or decision if there was no settlement agreement? Because it seems to me from what you are saying that earlier on, You suggested that they should do an inspection, which they went and did. Then they came back and presented argument before you. During the argument, one of the parties accepted a certain proposition from the other side. But they didn't say to you, we have resolved the matter. And if they didn't say we have resolved the matter, on what basis did you not give an order or judgment then?
Chief Justice, I'm going back a bit, but my recollection, and it may be faulty, but that is my recollection, is that in engaging, it was accepted by the parties that those who had been demolished and they were identified, they could, the application was to stop an eviction or to allow them to go back or whatever. And I was comfortable that that had taken place. So I accept that I should have made a note, but I'd understood that it had been resolved, and the fact that nobody came back indicates to me that it had been sorted out and my understanding was correct.
But come back from where? Because the inspection had happened before
Yes.
this second time of argument. So they were to come back from doing what? The second time when they came back to argue, there had been an inspection. They argued.
There was a pig-headed,
There was some-
sorry, there was, I mustn't use that term. There was an attitude adopted by certain counsel that did not make sense, and I then fleshed it out, and then it was accepted.
But at the end of that session, did they say we have resolved the matter?
No, I'd understood that they had. They did not say so expressly. I'd understood that they had identified and had worked out through the problem and through my engagement with them.
So they had an argument before you for you to decide the matter. They left without saying they have resolved the matter, and they did not say you don't have to make an order. They didn't say you don't have to give a judgment, but you decided not to give a judgment because during argument, some proposition was accepted.
Yes, they had accepted that this was the rational way, that you can identify who the people were, and that was it.
Okay, I think.
CJ.
Oh, okay, I'm sorry.
Yeah, CJ, I was just, you took from me when I was doing the.
You want a follow-up?
That follow-up, yeah.
Okay.
So now, we are now agreeing that.
Sorry.
What the CJ was saying to you, which you agreed to, that you heard it from someone, it doesn't exist. It's not true. It's not correct. You didn't hear from someone that there was a settlement.
No, it was during the course of the arguing and putting positions or putting my concerns or putting my understanding to the parties.
So now I'm saying you are leaving that one, that argument that we were saying you heard from someone that they've resolved.
No, I don't believe I ever said that.
You said that the CJ said to you, you heard it from someone. And you said, I heard it from someone that the parties have resolved this matter. We are leaving that one.
No, I don't recall saying it. I don't believe I said it. If I did, it was always incorrect if I did say it. But my recollection is that it was after the inspection, but it was always the parties themselves who were before me, and I certainly didn't hear from anyone other than, or make any assumptions other than from what was put to me and what was argued before me and their responses, but it was only the council involved.
Yeah,
So
but-
there's no misunderstanding on that.
Okay.
There was no third party.
So let's leave that one. Even on this one, the parties have never said to you, we have resolved this matter. They've never said that.
Not expressly. I understood that they had.
Eh?
Not
Well,
expressly, no. Not
I
expressly.
might not understand those things of expressly, and I'm not a lawyer, I'm a layman. I want to live here and go and explain properly.
Yeah.
No one ever said to you, we have resolved this matter, of the parties.
Sorry, can I just try and recall? I may have put, then, is there any issue where A, B, and C are accepted D, E, and F are accepted. And that's it. Yeah, my difficulty is that I've tried to get correspondence that preceded this, because there was correspondence that preceded this, but I can't.
No, Judge.
If I may, sorry, my apologies. I don't mean to be disrespectful.
No, I hear you, but I'm saying to you, in your own ways, there's nothing wrong with accepting that, the version you have put to us. I'm trying to put it in a layman's perspective. That which you are doing now of trying to say, you have said this, and then you have said that, you all do that all the time. And then Mugai Tobe and them will say, no, the other party has conceded, the other party has. Conceding and not conceding does not mean you can't deliver judgment, or you conclude that now the other party, because it conceded, it means now there is an agreement. And then there must not be a judgment. You know that. That is not how the procedure is followed. All I'm saying is, as they were busy conceding to you, as you put them to this side and put to this side, they were conceding to you. None of them, at the end of those concessions, none has ever said to you, we have now resolved this matter through your wonderful intervention.
No.
No
that's
one
correct.
said that.
That's
Yes.
quite correct.
Thank you.
Thank you. Commissioner Dodovu, are you covered or not?
Thank you, CJ. CJ, I never wanted to say anything on this session, but for the reasons that I'm convinced that you best know,
Yeah,
I want to follow up this particular matter.
okay.
Now, Justice Spilg, throughout this interview for the last 2.5 hours, your buzzword has been fairness, and justice. Do you think in your good conscience that you were fair to the parties who appeared before you, who spent their time, who spent their money, who made heads of arguments to you and say that you must resolve the matter as a justice of the court? Do you think that you are fair? You are fair to these parties?
Thank you.
I just want to follow up on that question so that Judge Spilg answers 2 questions.
Yeah,
I think
okay.
what I'm most concerned about, Judge Spilg, on this, and I think it's probably fair to put to you, is that you are asking to be appointed as a judge of appeal in a court whose word is final, except at the Constitutional Court. You take a junior judge who does what you have done, which seems to amount to an abandonment of a judicial function, and a complaint comes before you. Would you really endorse that conduct?
Sorry, would you?
Would you, as a senior judge of appeal, endorse a conduct of a junior judge who did what you did, which is to abandon a judicial function?
Thank you.
Do you remember to answer
Yes,
both?
of course.
Yeah.
The first question related to, do I now consider what I did fair? In light of what took place there, in light of the fact that nobody said, we need an order, what has happened? I'd understood that it had been sorted. At that time, I considered it fair. Now that there is a complaint that has been lodged, my first question is, well, why was there never a request? Where's your decision? People are in limbo. Nobody's in limbo, as far as I understand it, because they would have raised it. Insofar as an abandonment of a judicial function, I made a call in an urgent court week. Maybe I should have made a note. I should have called the parties back. I can't recall the sequence of events. What I do know, and I put it there, that there were 27 urgent matters that I was dealing with. And if you consider it an abandonment, I don't. It would have been an abandonment had I been asked straight after or any time after that, please, you've overlooked this or you haven't given a judgment, and I did nothing. That I would consider an abandonment. Thank you.
We are going to,
No, I just want to say the
Oh,
last
okay.
thing, CJ.
yes, sure.
During the closed session, when we discuss, when we deliberate on this interview, I'm going to say, and I want you to comment on that because I don't want to say it in your absence. I'm going to present a view that says this judge is not responsible. He has abandoned the case that is very important, and he expects the people who appeared before him to tell him to deliver the judgment. And on his own volition and accord, he cannot exercise a judicial duty that is befitting a judge to deliver a judgment. What is your view on that?
With respect, I would ask you then to take into account the view of my peers, of the judicial officers who are here, who can perhaps answer better. So I don't want to engage in an issue where my track record is here. It's in this. What I've done, whether people respect me or not, appears from the reports you've got. So it is a factor. I accept it's a factor. But I am responsible, and I've been made responsible for, aside from my judicial functioning, which is set out by the views of the legal profession, also responsible and convene 2 committees within the High Court. So my conscientiousness, my dedication, if this is seen as anything, at best it's a slip-up. But to consider that with respect as the Spilg that is known by the judiciary and by the practitioners, I would leave to those who have for better part of 14 years engaged me. Thank you.
Thank you, Sir.
Thank you. Well, Judge Spilg, we are going to end this interview. But I'm surprised that
Sorry,
you had...
Chief Justice.
Oh, I'm sorry.
No, it's just you can ask this for
Okay.
me. I just want to know, now that you know those parties are still unhappy because they have not received their judgment, will you deliver the judgment?
Absolutely.
And by when?
I
Just
can do it
for-
within 2, well, I'd need to find the bench book. But, I just need to be practical, if you don't mind. I need to find the bench book. I am happy not to get the record, the balance of the record, and I can do it in 2 weeks. But now that I know it's there, I can do it in 2 weeks.
We are ending this interview now, but I wanted to say I'm surprised that you handled this matter in the manner in which you handled it, Judge Spilg. Not only because you have been a judge for a considerable number of years, but also because prior to appointment as a judge, you practiced as an advocate and as a senior counsel for a long time. In my view, a very junior judge, an acting judge, would know that if parties have argued a matter before him or her, a judgment is required of him or from him or her unless the parties have resolved the matter and have told them that, and they would even preferably say, put it in writing, do a settlement agreement, unless they tell the judge in open court where it is recorded that they have resolved the matter. That would be done by a very junior judge, in my view. So I'm surprised that with all the experience that you handle this matter in this way, and now look at the controversy that it has raised. This is such a controversy should not arise out of whether the matter was resolved or not. And if when the parties left, if you were in doubt whether there was still a judgment expected from you, you ought to have asked the parties, in the light of A, B, C, D, do you still need a judgment? Or if they say they have settled, you say, give it to me in writing, or let's place it on record in open court. That's what would be expected from a judge.
Thank you, Chief Justice. My answer, and it may be unacceptable, may not be adequate. I was in an urgent court. I had many matters on the roll. I did the best I could. Sorry, I did what I understood was the situation. There is now a complaint that it is not what I understood. I'm more than happy to give that judgment in 2 weeks.
We have reached the end of the interview. Thank you very much, Judge Spilg. You are now excused.
Thank you.
Thank you.